Hey guys, it's me, Sylvia. I won't be on too long. I just came to give you guys some update in regarding to motions that was just submitted by Robert's attorney, Jennifer Bonjean. So guys, I will not be on too long. I just want to drop some nuggets of information and you guys could look at it in a replay. I got my Rita here. Hey, Purple Couch.
Howdy, how are you?
I'm good. How you doing?
Pretty good.
I'm I'm going to continue using this day as a day of rest for me, but I just wanted to get this information out to the people. So by the time
Okay.
folks come on up in here, I'll probably be off.
I know
So,
that's
okay,
right.
without further ado, guys, we're going to go ahead on and start the reading. You have the transcript, right? I mean,
You
that's
talking about the
ooh,
motion?
the motion, yeah. Okay.
Okay. Yep.
Thank
I'll
you,
read
guys.
it.
Thank you, guys.
Okay. Uh, this is Defendant Kelly's motion to bar the admission of highly prejudicial evidence during the examinations of co-defendant McDavid, any communications protected by the attorney-client or work product privilege, and motion to cross-examine McDavid after the government. Now comes defendant Robert S. Kelly buying through his counsel, Jennifer Bonjean and Ashley Cohen of the Bonjean Law Group PLLC, and files this motion to 1. Bar the admission of highly prejudicial other bad act evidence that may be the focus of McDavid's testimony, particularly on cross examination by the prosecution. 2. Admission of any testimony or statements that are protected by the attorney client or work product privilege. And 3. Motion to allow Kelly to cross examine McDavid after the government. By way of background, defendant Kelly moved to sever his case from co-defendant McDavid's case on the grounds that their defenses would necessarily be antagonistic. At the time of the filing of Kelly's severance motion, McDavid refused to share his defense with Kelly's counsel, as was his right. Kelly anticipated that McDavid's defense would involve denying any knowledge of Kelly's conduct as alleged by the government in the superseding indictment. Kelly argued that McDavid's defense, as it relates his knowledge, would place the co-defendants in antagonistic positions to the detriment of Kelly. 2. The prosecution objected to Kelly's severance motion, arguing inter alia that Kelly had overstated the risk of the government using McDavid's testimony against Kelly if McDavid took the stand. The prosecution denied any significant risk of prejudice to Kelly, claiming that Kelly had not identified specifically how the prosecution might use McDavid as a witness against Kelly. 3. With the benefit of McDavid's opening statement, it is now clear that McDavid claims that he was a member of Kelly's criminal defense team and that he had no knowledge about the contents of any tapes that allegedly depict child pornography. In McDavid's opening statement, his counsel stated that the evidence would show that McDavid acted at the behest of Kelly's lawyers and that McDavid entered a formal agreement with Kelly's lawyers to work as their agents. McDavid will apparently testify that he worked as an agent of Ed Jensen and followed his directions. Number 4, as this court recalls, defendant Kelly immediately moved for a mistrial after McDavid's opening statements, arguing that McDavid's defense was clearly antagonistic to Kelly, and further that by trying these cases together, Kelly had no ability to defend against the first 3 counts of the indictment. This court denied Kelly's motion for a mistrial. The motion was renewed after Brown's opening statement, which also reflected Kelly and Brown's defenses were antagonistic. This court denied Kelly's second motion for a mistrial while acknowledging there was some finger pointing among the defendants, but not sufficiently prejudicial to justify severance. Number 5, last week McDavid told the court that he plans to testify in his own defense. Today, McDavid made a production of materials that it may use in connection with McDavid's direct examination. Kelly anticipates that McDavid will testify as advertised in his opening statement that he had no knowledge about the contents of the videotapes 1 through 3, and that any actions he took was at the direction of Kelly's legal team because as acting as an agent of the legal team. Number 6, as previously argued, by forcing Kelly to stand trial with McDavid, he not only must defend against the government's case, but will have to contend with potential adverse testimony from McDavid that will be elicited on both direct and cross examination by the government. 7, of particular concern, Kelly anticipates that evidence concerning McDavid's involvement in settling many lawsuits and potential lawsuits against Kelly brought by many women will become central to McDavid's cross examination. Number 8, accordingly, defendant Kelly moves this court to bar testimony and documents related to the following subject matters: Kelly's alleged relationship marriage to Aaliyah, testimony regarding Kelly's alleged sex addictions, any reference to prior lawsuits filed or threatened by other Kelly accusers, or any settlements negotiated by McDavid on behalf of Kelly not directly relevant to the instant litigation. All testimony related to claims lodged formally or informally against Kelly for sexual misconduct or sexual harassment, Kelly's alleged relationships with any other woman not named in the indictment or directly relevant to the instant charges. All matters related to the Florida criminal investigation regarding Kelly's alleged possession of child pornography, charges that were dismissed after all evidence was suppressed. Any and all allegations, lawsuits, claims made by Kelly's employees against Kelly, testimony related to McDavid taking Kelly to get injections or any treatment to curb his sexual appetite, and testimony related to any other medical diagnoses of Kelly. 10. The foregoing categories of information, most importantly, evidence related to other uncharged allegations of sexual misconduct and evidence related to Kelly's arrest for child pornography in the state of Florida, is not pertinent to this case and amounts to nothing more than propensity evidence. As such, it is inadmissible pursuant to Fed R Evidence 404B. Furthermore, whatever probative value such evidence has is substantially outweighed by its prejudicial effect pursuant to Fed R Evidence 403. 11. Separately, Kelly moves to preclude McDavid from testifying about statements made to him by Kelly related to the 2002 indictment and subsequent 2008 prosecution. As McDavid represented in his opening statement, he served as an agent of Kelly's defense team. In light of his role as an agent for the defense team, McDavid is bound by the attorney client privilege and is not at liberty to reveal any communications intended to be confidential. 12. Attorney client privilege extends to third parties assisting the attorney in rendering legal services. Hecker and Koch, it's a lot of references right there of different citing. This includes agents of the attorney, such as paralegals, investigators, secretaries, and members of the office staff responsible for transmitting messages between the attorney and client, and to outside experts engaged to assist the attorney in providing legal services to the client, such as accountants, interpreters, or polygraph examiners. ID, the same principles apply to the work product doctrine. 13. Because McDavid worked as an agent of Kelly's defense team between 2001 and 2008, McDavid is bound by the attorney client privilege and work produce privileges. Kelly has not waived his attorney client privilege with his prior counsel. 14. Last, Kelly seeks to cross examine McDavid after the government conducts its cross examination of McDavid. Kelly has long maintained that he and Kelly sit in antagonistic positions. Kelly also maintains that the government will attempt to elicit information from McDavid on cross examination that will be damning to Kelly, not only as to the obstruction count, but as to the child pornography and inducements counts. Kelly cannot possibly know what to cross examine McDavid about until he hears the cross examination of the government and can assess what subject matters the prosecution is allowed to explore with McDavid. 15. Accordingly, defendant Kelly respectfully seeks an order: 1. Excluding the parties from examining McDavid about the subject matters identified; 2. Precluding McDavid from revealing communications protected by the attorney client privilege; and 3. Allowing Kelly to cross examine McDavid after the government. I, Jennifer Bonjean, certify that the that filed this motion to bar on September 9, 2022 via electronic filings. All parties to this action were served.
Do me a favor, check your email. I just send you government's response.
Oh, they
They on it's on tonight, guys. It's on with
I
this stuff.
see. Yeah, they
They're going back and forth with this fighting.
wow, this is crazy. Okay, so here's the government's second submission regarding admissibility of purported business records proposed by defendant McDavid. This is their response. On September 4, defendant Daryl McDavid submitted to the court 8 documents that McDavid intends to authenticate and offer through Marta Johansson, a former administrative assistant of private investigator Jack Palladino. Accompanying these documents is a purported declaration by Ms. Johansson in which she represents that these records appear to be the original or duplicates of the original records kept in the custody of Palladino and Sutherland Inc. Emphasis added. In its prior submission, the government set out in detail its objection to the wholesale admission of these proposed documents on the basis of the business records exception, Fed R Evidence 8036. In particular, the government argued Ms. Johansson could not serve as a qualified witness to authenticate and admit the proposed documents under FedR Evidence 8036D, giving her only passing familiarity with their originality. The government also established that the proposed documents were not immediately relevant to a fact issue in this case and may only be conditionally so upon the testimony of McDavid at trial. For the reasons set forth below, the government renews its objection to the admission of these proposed documents in evidence. To the extent the court nonetheless considers the proposed documents' admissibility, it should do so through a two-step inquiry that first considers their authenticity and then evaluates the foundation for their relevance in relation to McDavid's state of mind. The admission of these proposed documents, reflecting in many cases unfettered and highly biased commentary by a private investigator working on behalf of Kelly to recover tapes depicting child pornography, on Ms. Johansson's authentication alone risks significant prejudice and would run afoul of a suite of evidentiary rules as further detailed below. Their argument. None of the 8 documents proposed by McDavid is immediately identifiable as business record as defined by FedR Evidence 8036. As set forth in the government's first submission and reply on this issue, CR 299303, each proposed document bears significant questions of whether the source of the information and the method or circumstances of preparation indicate a lack of trustworthiness. They cited a case. This is because most of the documents are addressed to attorneys or were otherwise prepared in the context of anticipated litigation, with some directly referencing efforts to develop impeachment evidence on expected witnesses. That's another citing. Others suffer from a significant lag between the creation of the document itself and the underlying event or transmission of information. And as noted above, it is not clear that Ms. Johansson can attest to the proposed documents as being kept in the regular course of Mr. Palladino's business. To authenticate the documents or to admit them as business records, the court will first have to measure whether Ms. Johansson can testify as to the documents' adequacy under all these conditions and in a manner that overcomes the government's showing of indicia of untrustworthiness. But the determination that a document meets the test of authenticity does not end the inquiry, where defendant has raised relevance objections to many of the documents and argues that the contents of all of them are inadmissible hearsay. Another site, okay, as previously noted and as described in detail below, the proposed documents are potentially highly prejudicial, replete with hearsay and hearsay within hearsay, and often lack relevance to a fact issue in this case, a factor to which Ms. Johansson will be unable to speak to. The apparently wide ranging nature of Mr. Palladino's investigation means that the proposed documents related to individuals that are neither witnesses nor otherwise implicated at trial and events that are not within the bounds of the conduct charged in the superseding indictment. Where the documents do discuss relevant conduct and personalities, they are colored by the biased commentary of investigators hired at Kelly's behest. And the documents contain and indeed rely on purported statements of third parties, in at least two instances taking the form of unsigned declarations. Authentica- Authentication offers a solution to none of these issues. The government expects that McDavid will attempt to surmount these evidentiary barriers by testifying as to how reading the documents impacted his state of mind, pursuant to Fed R Evidence 8033. It remains to be seen whether McDavid's testimony will qualify under that particular exception to hearsay. Another case cited, but even if his testimony can ameliorate hearsay concerns, it does nothing to remedy lack of relevance or the bias and prejudice inherent in the proposed documents as outlined below. Document 1 is a collection of summaries of telephone conversations with a non witness individual named AW, a purported victim of Kelly's, and conducted unrelated to the charge offenses. Document 1 should be excluded under FedR Evidence 401 and 403. Document 2 is a brief summary sent to a public relations crisis communications firm describing a private sting operation that targeted persons unrelated to the charged offenses. Document 2 also merits exclusion under Fed R Evidence 401 and 403. Document 3 is an unassigned declaration of non witness AW, the contents of which are unrelated to the charged offenses. Document 3 is likewise excludable under Fed R Evidence 401 and 403. Document 4 is a memorandum to counsel summarizing interviews of Jane and members of her family. Dr. 4 is excludable under Fed R Evidence 403 as cumulative of the direct witness testimony of Jane, Susan, and Detective Everett at trial, and as containing prejudicial statements regarding Jane and other witnesses. Document 5 is an unassigned declaration of Jane, who has already testified and been subject to cross examination at trial. Document 5 carries the significant potential to be unfairly prejudicial, confuse the issues, and mislead the jury, and should be excluded under Fed R Evidence 403, particularly given that the defense chose not to present Jane with this document during cross examination. Document 7 is a memorandum to counsel regarding two intermediaries, Chuck Freeman and Charlucy Feeney, with regard to their knowledge of and ability to resolve a matter unrelated to the charged conduct. Document 7 contains improper extrinsic evidence of a witness's truthfulness under Fed R Evidence 404B and 608B, along with prejudicial characterizations of Freeman and the nature of the investigation. Document 8 is a compilation of documents, including memoranda to counsel and reports summarizing witness interviews conducted in an effort to gather impeachment evidence against Freeman. Document 8 is impermissible under Fed R Evidence 404, 608, and 609. It also contains commentary from investigators with regard to Freeman, which would be prejudicial under Fed R Evidence 403. Document 9 is an invoice purporting to itemize activities and billable hours related to efforts to recover items for Kelly. Document 9 contains prejudicial descriptions of investigative work conducted by Palladino, which would violate Fed R Evidence 403. Unless and until McDavid testifies, these documents will remain only conditionally relevant. See Fed R Evidence 104B. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The proposed documents cannot be admitted prior to McDavid taking the stand and cannot be admitted on the authentication of Ms. Johansson alone. Prejudicial and cumulative content, along with improper character evidence, can only be resolved through redactions after a proper relevance foundation has been laid, if the document is not precluded from admission in its entirety. Ultimately, the only means by which to safeguard the jury from receiving improper evidence in the form of the proposed documents is the two-step process proposed by the government. First, to determine the authenticity of the proposed documents through the testimony of Ms. Johansson, and second, to determine their relevance and admissibility through the testimony of McDavid as to how they affected his state of mind. Anything short of the above described process bears significant risk of prejudicing the jury through the introduction of improper evidence. Conclusion. For the foregoing reasons, the United States respectfully requests that the court exclude the proffered documents from admission into evidence at trial, or, in the alternative, conducts a two-step test to determine both their authenticity and relevance prior to admission. Submitted by Janice, Elizabeth, Jason, and Brian.
Thank you. Thank you so much.
Mhm.
Um, it's strange how they were able to bring stuff those
Okay.
taping without the change of custody,
Or
but
true authentication.
yeah, without, and now this they can't bring in the notes from the investigator. This is like so like
Crazy.
unfair to me. I
Wow.
don't get it. I don't get it at all.
Wow.
I don't get
Wow.
it. It's just a dirty thing that seems like they're playing. But ladies, I thank you guys. Did you guys want to say something? Because you know me, I'm ready to get off. Anybody wanted to say something? Missy, did you want to say something?
No, I'm good.
Okay. All right,
Yeah.
guys. I just wanted to bring you guys this reading. Hopefully, I'll get back to our transcript reading. We have a lot of reading to do. We have a lot to do, and I'm just not feeling it, guys. You know what I mean?
Yeah. Yeah. And it's all good. It's all good.
Yeah. Just so
When you're ready, that's when we move forward. But glad you're resting, and now you got to gear up for tomorrow.
yeah, gearing up for tomorrow. But thank you again, ladies. I appreciate you guys taking the time to come in and read. Big hugs to you guys. Thank you.
Same to you, and
All
you're
right.
You're
welcome.
welcome.
Good night, guys.
Good night.
Good night.